You're in the water loop.
Waterloop is made possible in part by grants from Spring Point Partners and the Walton Family Foundation.
Waterloop.
Hi, this is Travis with Waterloop. Right now, more than half of the United States is in some form of drought. It's not just out west. It's up in the Pacific Northwest. It's in the upper Midwest. There's drought in New England, and there's even dry conditions here in North Carolina where I live. Almost 80 million people live in some part of the country where there's drought. During times like this, every drop really does count. Shower heads are an easy way to conserve water in our homes. That's why I use High Sierra shower heads at my house, and I'm really proud that they're a sponsor of this podcast. They carry the EPA WaterSense label for water efficiency and use 40% less water than conventional low-flow shower heads. They use just 1.5 gallons a minute. So what does that come out to? For every minute you're in the shower, you're saving 1 gallon of water. You take a 10-minute shower, that's 10 gallons of water you have not used because you have High Sierra shower heads. Over the course of a month, that's 300 gallons of water that have been conserved. You're going to also save on your water bill and your energy bill. You can get 20% off using promo code LOOP20 at highsierrashowerheads.com.
You're in the water loop.
Welcome to Waterloop. This is Travis. Going to be talking about Clean Water Act for this episode and its jurisdiction and what's known as Waters of the United States. I am honored and delighted to be joined by two guests who've been extremely close to this issue, as close as you can really get. They were both the former heads of the Office of Water at the U.S. Environmental Protection Agency, a role called Assistant Administrator for Water. I have Ken Kopocis. He held this role under the Obama administration. Ken, thanks for joining the podcast.
Thank you.
And also have Dave Ross. He held this role under the Trump administration. Dave, thanks for coming on as well.
Yeah, thanks, Travis. Thanks for the invitation.
Yeah, I'm really excited to have both of you and have your incredible perspectives and knowledge brought to this issue. So for listeners, I want them to know that we're going to take a little bit of time and kind of go over the history of Clean Water Act and Waters of the United States, just to set the table here. And then we're going to spend a lot of time getting your thoughts on this complex issue and its storied history. And there was a new chapter in that history just written at the last days of August, where a federal judge in Arizona, struck down the Trump rule. And we'll touch on that and what that could mean as we go along. So great. Looking forward to this. Really excited to have folks from two different parties, that were served under two different administrations here. So Ken, let's start with this question for folks. What is the Clean Water Act?
Well, fundamentally, the Clean Water Act is the federal law that protects our surface waters from pollution or destruction. And by surface waters, these are lakes, rivers, streams, wetlands, and near-shore ocean waters. And the scope of the Clean Water Act, I think, is summed up in its initial sentence, and the objective is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. So it's extremely broad in its intent as to what Congress intended it to do. And the way it works is it's complicated yet simple conceptually. It prohibits the discharge of a pollutant from a point source without a permit or otherwise in compliance with the law. Now, the concepts of discharge are broadly defined in the Act. A pollutant is broadly defined in the Act, and what constitutes a point source are broadly defined in the Act, and take up reams of paper in the Code of Federal Regulations. But as I said, conceptually, it's fairly simple. I think it's also important to understand that EPA has the general oversight for implementation of the Act, but the Corps of Engineers also has a role in the permit of dredge or fill material into waters of the United States. Primarily, they exercise it in wetlands. And also that the day-to-day implementation of the Clean Water Act is carried out at the state level by the states with EPA assistance and with EPA having an oversight role.
Thank you. And we are coming up on the 50th birthday of the Clean Water Act in 2022, I believe in October, if I recall correctly.
The 18th of October.
All right. Got the month right. Dave, this waters the United States, this term, and a water being covered under the Clean Water Act. What does that all mean?
Well, I think there's a bit of a misconception when people talk about waters United States and being covered under the Act. The thing to remember is the Act defines waters United States, or defines navigable waters as waters United States. It's a term of art that really triggers the regulatory programs of the Clean Water Act that Ken so helpfully laid out. Ken mentioned the overall objective of the Act is to restore the nation's waters. But underneath the Act, there are regulatory programs and then non-regulatory programs. And so as we're talking about waters in the United States, I think it's helpful for people to remember that when you're talking navigable waters, when you're talking waters in the United States, you're talking about the regulatory programs. When do you need a permit? When do you need a permit to either discharge a pollutant or to do development activities in wetlands? And it's also where the major water quality standards and a lot of the regulatory programs that the states implement on behalf of the federal government, where those standards are applied to the waters in the United States. So regulatory framework versus the non-regulatory framework of the Clean Water Act. It's actually a very, very comprehensive statute, as Ken mentioned, and it does a lot more than just cover waters in the United States.
So jurisdiction. Who is responsible for determining jurisdiction of the Clean Water Act?
Well, I'll take that, Travis.
Sure.
Ultimately, it's EPA. EPA is the final authority over what is or is not a waters in the United States. What is the jurisdiction of the Clean Water Act? This was actually an open question in the 1970s because the Corps is given such an important role under the program, and they run the 404, the Wetlands Permitting Program, the Dredge and Fill Program. And so, practically speaking, the Corps is making determinations over jurisdiction on a daily basis. And so if you go out to the core districts, they really are, the nation's experts on the day-to-day basis as to determining jurisdiction. But if there is a dispute and who gets to decide an actual jurisdictional call, ultimately, and there's an Attorney General's opinion in the 1970s that has sort of withstood the test of time, ultimately it's EPA's decision as to what is or what is not a waters in the United States subject to Clean Water Act jurisdiction.
Well, thank you both for kind of laying out some of that critical context there. So getting into the history, when did these significant questions about jurisdiction arise, and what were the issues? Maybe I'll put that one to Ken.
Okay. Well, interestingly enough, you mentioned that we're coming upon the 50th anniversary of the Clean Water Act next year. And the significant questions about jurisdiction arose as soon as the act was enacted, actually. The Congress tasked both EPA and the Corps with responsibilities under the act, as Dave said, and that EPA took a very broad view in its regulatory definition of what constituted waters of the United States, and the Corps of Engineers took a very narrow view, limiting it to only those waters that were truly navigable in fact. And in part, that was because that was the history of the activities of the Corps. The Corps had had regulatory responsibilities in navigable waters dating back into the 1800s. And when Congress used the term navigable waters, the Corps chose to define it narrowly within its scope. There was litigation. The Corps was ordered to revise its definition. As Dave mentioned, then Attorney General Civiletti issued an opinion in 1979 that said that the decision on what is or is not covered by the Clean Water Act belongs to EPA. And so once the Corps revised its definition, it closely mirrored that of the EPA. And so since the late 70s, very early 80s, EPA and the Corps have had highly similar. They're not necessarily 100% identical, but the differences are so nuanced that it's a practical matter. It really doesn't make any difference. The Corps and EPA have been working off of the same format as to what is regulated. So jurisdictional issues started to arise, not so much over lakes, rivers, streams, nearshore waters, as I mentioned, but primarily around wetlands and around people who wanted to do development in wetlands or people who actively worked in wetlands. And the people who actively worked in wetlands most commonly around the nation were in the agricultural sector. And so the activities that prior to 1972 may not have required a permit to be conducted suddenly may have required a permit to be conducted. And it also affected people in the property development industry and in the resource extraction industry. And so it became necessary to further embellish, or not embellish, but to further inform people as to what was or was not covered by the Clean Water Act because of this new broad regulatory program that Congress had enacted. And so the use of the term waters of the United States as the definition of the term navigable waters, which is the term that's used throughout the act, created this tension between people who said that the act should be limited in its scope to only those truly navigable waters, and those who indicated that waters of the United States should be interpreted as broadly as it could be under the authority that Congress had granted to EPA and the Corps.
And I really want to know then what actions the agencies started to take. I think that under the Bush administration in 2007, 2008 is when kind of this chain of events, if you will, started. So maybe, Dave, could you explain what happened then under the Bush administration?
Yeah, sure. Well, I guess, the law of the land when the Bush administration came in was, based on the 1986 and 88 versions of EPA and the Corps of Engineer regulations. Over time, the courts would weigh in as to whether or not a water body is jurisdictional or not. And that, those disputes made it up to the Supreme Court in 86 or in the mid 80s and again in early 2001. It made it back to the Supreme Court, and over a dispute about jurisdiction over wetlands, connected to ditches that eventually flow into other waters, which eventually get into a navigable water. In a Supreme Court decision in 2006 called the Rapanos case, and that really, as the tension, in the disputes would grow over the decades, I think that's really a high mark, or perhaps maybe a low mark, in the debate over what's a water in the United States, because you had a fractured opinion, the Supreme Court, a 4-4-1 decision with 4 justices on both sides being fairly clear about where they thought the scope of jurisdiction was, and then a single justice, Justice Kennedy, who wrote an opinion joining the more conservative court members in an outcome of the case, but having a different view about how you establish jurisdiction. And, in that decision, even the Chief Justice at the time expressed some frustration with EPA and the Corps over not better defining in regulation what is a water in the United States, particularly these more attenuated waters. And so EPA, under the Bush administration, thought about doing rulemaking, but ultimately put down guidance, what's been called the Rapanos guidance. And they first developed it in 2007 and updated it in 2008. And they tried to put down some guidance as the different categories of waters. And as Ken mentioned, there really isn't much dispute until you get out into whether or not in the drainage territory, in intermittent or ephemeral drainages, or wetlands that are not really right next to other significant waters. And so they put down guidance, and they aimed after, what is a significant nexus test under Justice Kennedy's individual decision. And that, is how EPA and the Corps have, using that guidance, have implemented the 86 regulations over time. But it, I think to some members of the regulated community, it sort of lacked the certainty that I think folks would prefer to have in a rulemaking.
Great. And then if we jump forward to the Obama administration, and Ken, at the time you were at the agency leading the Office of Water, what rulemaking happened then? What was the activity and the intent there?
Okay. Well, first, I want to say that Dave did a really good job of kind of laying the groundwork of what we inherited coming in. When in 2008, I was on Capitol Hill, and people were asking Congress to please legislate in this area because nobody liked where things were. And of course, people asking for a change, some wanted it to change in one direction, some in the other. But the one thing that was certain was that nobody liked where things were. We had the Swank case in 2001, and we had the Rapanos case in 2006. Both of them affected how the agencies should be implementing the law, and yet the regulation that underlied all the actions of the two agencies hadn't changed at all. Neither of those Supreme Court cases said that the invalidated any of the regulation, but what the court said the agency should be doing did not match up well. So the agency decided that it was going to undertake regulatory action. As Dave said, the Bush administration talked about doing it. There was some pushback in what they were talking about, and they decided just to leave it alone and go with guidance. But guidance is not particularly popular in the regulated community because of the lack of certainty that Dave mentioned. And in candor, one of the problems with lack of certainty is all agency guidance says clearly on its face the agency is not bound by it, and it confers no rights in a regulated entity. And secondly, it's very difficult if you want to challenge guidance to bring a court case and get a judge to rule that guidance is arbitrary and capricious, where the agency has said it's not binding on anybody. So we set out to develop a rule, went through an extensive process, which we can talk a little bit more about later, but decided that the best solution was to issue a rule. During the Obama administration, we also looked at doing guidance to try to clarify the jurisdiction, but ultimately, in coordination with the various parties that were involved and our colleagues within the executive branch, we decided that a regulation was really what was called for to provide more clarity and more predictability on jurisdiction under the Clean Water Act.
And what if you could summarize maybe the gist of the regulation that came out in 2015? Where did it go? What was the thrust of it?
Well, the thrust of it was to match the regulation with what we knew from the Supreme Court in both Swank and Rapanos, but most importantly in Rapanos. It was trying to reconcile the test that the court had laid out of significant nexus. That Dave mentioned that Justice Kennedy based his concurring opinion on the significant nexus test. That significant nexus test was also part of the court's decision in Swank in 2001. And so the agency felt that was a good place to go in terms of establishing how waters were connected to each other and how far the agency's authority should extend in protecting waters from pollution or destruction. It was also, we thought, time to better inform the public, the regulated entities in particular, but also those who felt that the waters needed to be protected as to what the agency felt were waters that were covered by the Clean Water Act and waters that were not covered by the Clean Water Act. That was a key component in both instances. We felt that we were trying to do, or that we did a better job in being more clear as to what's included and also more clear as to what was excluded. There were different exclusions that were not binding on the agency because they were part of a preamble, and we incorporated a lot of those into the rule itself to bind the agency and limit its scope of what was jurisdictional.
Great, thank you. And then to the next administration, the Trump administration, Dave, when you were heading up EPA's Office of Water, you all took regulatory action. Could you explain that?
Yeah, well, first, I think the important thing is the Obama administration did roll up the sleeves and do the hard work of doing a rulemaking. As Ken mentioned, both the 2001 and 2006 Supreme Court decisions did affect the way WOTUS was implemented out in the field, and there was tension between what was on the books and what was actually being applied out in the field. And so, to roll up the sleeves and do the rulemaking, really, really hard work. and also to begin to define in some of the exclusions what are in and what are out. And so, with that foundation laid, there's a lot of litigation. Really not about whether or not to do the rulemaking, but it really was about how far the rulemaking went. And there was, I think Ken will appreciate that. I'm sure he was attacked for not going far enough, and was also attacked for going too far. And so there's a lot of litigation, particularly with the states. About 31 states sued the Obama rule and had some success early on, which quite frankly led to a patchwork of regulation on the landscape where you had different regulatory regimes based on which state that you were in. And I think everyone agrees that is absolutely bad government. And so the Trump administration came in an executive order, said we're ordered EPA to revisit the 2015 rule. And so I was charged with doing that. And the approach we took really was to, given the litigation profile, do a two-step rulemaking where we effectively took the Obama rule off the book and then set about our task of rewriting WOTUS. And so, the two-step framework, which I think, Ken you'll maybe mention, coming up as we march chronologically through, the theory was, because of the litigation, the two-step rulemaking, the first step would be, depending on what happened on our second step, the baseline would default back to the 86 regulations, which, as Ken and I both mentioned, were there, were known. Not a lot of people loved them, but at least it was a multi-decade framework that people could rely on as we then went and did the Trump rule. Travis, I think you asked Ken to give a little bit of overview of what the Trump step 2 rule was about. Practically speaking, what we tried to do is build off that certainty where the Obama regulation was going on. What are clearly in, and what are clearly out. And then I think what we tried to do is eliminate some of the subjectivity associated with a significant nexus test. And so really try to go a step further and from a clarity, certainty standpoint, and put down what truly categorically what's in and categorically what's out, and then kind of build out some of the definitions. And so, I think the major changes jurisdictionally were obviously in the ephemeral versus the intermittent cutoff on which flowing waters are regulated. The Trump administration drew a pretty bright line between all intermittents are in, but the ephemerals are out. And then I think there was a replacing significant nexus with additional tests for how do you regulate wetlands, bringing the watershed in closer to regulated watershed in closer to the main stems of the regulated waters. And again, to no surprise, the Trump rule was immediately litigated as well, and that leads us to a new administration and a new time. So maybe I'll turn it back over to you, Travis.
Yeah, absolutely. Yep, as you said, the political party in the White House has flipped again, and you have the Biden administration, and they've sent signals on waters of the United States. Ken, could you maybe cover just what the latest is from this administration, and then also mention the court ruling in Arizona and what implications that has?
Sure. The Biden administration has indicated that it wants to revisit the subject again, and is looking to revise the definition of what is a water of the United States under the Clean Water Act. I think that and in the interim, it was their intent to allow the prior administration rule to continue. It was no secret that the incoming administration was likely to take a more expansive view of what is covered than the prior administration did. That I think would be expected by everybody who's involved in this conversation. But they also made it clear that their intent was not to simply do a resurrection of the 2015 rule. that in fact they wanted to go through a process. People had seen the 2015 rule. There was experience with the 2015 rule in about half of the states, as Dave mentioned. The patchwork, if you looked at a map of the 50 United States and territories, you would see it definitely looked like a patchwork as to which rule applied in which states. And I don't think anybody would find that to be a way to run a regulatory program. So what the current administration wants to do is they're currently engaged in a process of public outreach, and then they intend to take a new, fresh look at what should be included in the Clean Water Act. As you mentioned, just late last month, a district court in Arizona sided with people with some tribal interests, primarily that were challenging the prior or existing rule that was issued under the Trump administration. The judge did two things: remanded the rule back to the agency, but also with vacatur, which meant that the rule would not be available to be used in any of the 50 states. So at this point, I don't think EPA publicly EPA did not ask for vacatur. EPA asked for the remand to the agency to reconsider the rule, which made a lot of sense considering that the agency had already publicly announced that it was going to reconsider the rule. But there were the parties, the plaintiffs did ask for vacatur, and the judge granted it, suggesting that in the Ninth Circuit, the precedent was extremely unusual, that a rule would be remanded to an agency but allowed to remain in effect, if you were. So the current status is the judge has ruled that the prior administration rule is not to be used, and EPA has, to my knowledge, has not yet made a public announcement as to what they see as their next step going forward.
You know, I with Waters of the United States, I feel like I'm at a tennis match, right? When you see the audience and they're just looking back and forth, and there goes the ball to that side and that side. It's just, back and forth, back and forth. I do want to mention, and I think you both agree, and the same career staff have been at the Office of Water throughout so much of this back and forth. And it's just incredible to me to see the work that they put in serving, the different administrations. And like you both have said, this is hard, a lot of hard work, a lot of sleeves rolled up, hours and hours, months and months, years and years. And so I just kind of want to give a shout out to all those folks that worked under both of you. All right, so let's roll up our sleeves here and have a little more fun. Why is it so difficult to define waters of the United States? Why is this so challenging? Why does it keep going back and forth? Maybe we'll start with Dave. Your thoughts on that?
Yeah, well, hey, thanks, Travis, and thanks for the shout out to the career staff. They truly are amazing, amazing professionals, and I just. For them to continue to have to do this, I love them. They're great people. And so thank you for that shout out. Why is this so difficult? Well, one, because Congress failed us, back in 1972, when it so helpfully defined navigable waters as waters in the United States. In the legal terms, where you have sort of ambiguous statutory constructs, it's up to the regulatory agency with expertise to sort of fill that knowledge gap. And the agencies, both the Corps and EPA, have been trying to do that for 50 years, resulting in a tennis match. Some might say it's even getting closer to a ping pong match. The ball's accelerating. And that, I think we all agree that that's just not great government. And so I think originally, you have to look at Congress as the original problem. The other thing, I think, there are a lot of reasons, but the other is to do a nationwide rule with such different hydrologic regimes in the landscape. That is really, really difficult. So, I've lived in California and Wyoming and Virginia and Vermont, and Wisconsin, and you hike, work, live, canoe in the land. Every single water body is different, and to try as a nation to regulate with one set of rules, where water means different things, whether or not too much, too little, in different parts of the country, is really challenging. And then feathered on top of that, you've got state rights, state authority, both regulatory on water quality, but also water rights. Who gets to who gets to say what you get to do with the water? And it just makes it's just a recipe for impossible regulation. And so I think I'd put it there: hydrologic regime and Congress.
Great. Ken, what are your thoughts on the difficulty of this task and why it's so complex and to get a landing spot here?
Well, first, I want to join both you and Dave and say that I've spent well over 30 years working in the political arena in Washington, most of it on Capitol Hill. But my time at EPA, I've never worked with as dedicated a team of professionals as I found at EPA. I often said, one of the great blessings at EPA was virtually everybody that works there came there because they wanted to work at EPA. During my time on Capitol Hill, I worked with an awful lot of people who didn't care about anything except they wanted to get experience so they could leave Capitol Hill and make money. And nobody at EPA is making money commensurate with their level of expertise and dedication to the job. So they serve all administrations extremely well. Well, in getting back to your question, I think Dave makes a lot of good points. Congress is certainly part of this equation. I think that one of the things I would mention as well is that you have to realize this is difficult because Congress's power is limited, and therefore the federal interest is limited, and lines have to be drawn. I was always envious of my colleagues in the Air Office because we knew what the Clean Air Act applied to. It applied to the ambient air that surrounded us. We knew in the Office of Water what the Safe Drinking Water Act applied to. It applied to the quality of water at the tap. But when it comes to defining what is subject to the Clean Water Act, now you have to draw lines. Because Congress's power is not limitless when it comes to surface water features. I once spent a day with scientists from the U.S. Soil Conservation Service out in the field to do wetlands delineations. And one of the telling things that I've always remembered from that trip was the scientists telling me, I can tell you what's dry land and I can tell you what's a wetland. The hard part of my job is telling you where to draw the line. And that is true throughout the Clean Water Program, is trying to figure out when is a small stream sufficiently important based on its downstream impacts to the navigable waters that it feeds into. When is an adjacent wetland something that is impacting the quality of the water to which it's adjacent? Or as Justice Kennedy said in his concurring opinion, sometimes a wetland is important because it keeps water from getting to navigable water. It serves as a collection point and a way to saturate the groundwater and recharge groundwater. So the answer, there is no perfect answer. And because there's no perfect answer where people can go to a data set or otherwise draw a conclusion that nobody could dispute, in many instances, then it leads to this confusion and it leads to what we're going through right now. I personally think that we weren't doing badly until the Supreme Court decided in Swank, but most importantly, when the Supreme Court issued that fractured opinion in Rapanos that Dave referred to, it threw everything into a state of confusion with various interests all arguing that the Supreme Court was on their side, and then it left it up, unfortunately, to the agencies to try to clear up this muddled mess that Congress is incapable of addressing.
Fantastic perspective from you both. We're going to keep going along these lines. And I mentioned before this podcast, I was really excited to have two people on from two different political party administrations to have a candid and productive conversation, something that I think is somewhat lacking or very lacking in these times. And when we've chatted off air, it's been really interesting. And so I'm looking forward to these thoughts here. A lot of misconceptions, I think, or misframing of each of your administration's approaches to waters of the United States. And love to hear your thoughts on kind of what was most prominent misconceptions or the most prominent distortions of each of your administration's actions on waters of the U.S. So maybe start with Ken.
Sure. Well, there were several. I think probably the most predominant misconception was that the rule was an incredible expansion of the reach of federal authority over waters in the United States, and it was anything but. I think that it recognized the limitations that the Supreme Court had given the agencies in both Swank and Rapanos, and it was characterized as this great expansion of federal authority. But in fact, we thought of it as more of a reflection of the way the agencies had been implementing the act. I think in many instances, it wasn't an expansion as much as it was a realization on the part of the potentially regulated community just how many activities might be regulated under the Clean Water Act based on what the authority Congress gave the agencies in 1972 and how the agencies had been implementing the act. I think that the act is by no means implemented uniformly across the nation. As Dave mentioned, in talking about who makes the determinations of jurisdiction, overwhelmingly those determinations are made by the Corps of Engineers. The Corps of Engineers has 38 districts around the nation that makes these determinations. And the Corps will readily admit, and anybody who follows this would readily admit, that if you took the exact same circumstances and gave it to all 38 districts, you would not get the same answer 38 straight times. So there was this ambiguity and this lack of certainty that existed out there. So I think that another misconception was that we were regulating land use, and that any activity inside a floodplain was suddenly going to require a permit from EPA, which of course, first of all, was EPA was much easier to be the boogeyman because EPA doesn't issue these permits, the Corps does, but it was always EPA that was criticized. And of course, land use wasn't being regulated as long as you didn't affect a jurisdictional water, whether it be a stream or wetland or an adjoining water. A third one was that we were trampling on states' rights. And I always found that to be a little curious because I wasn't sure what state right we were affecting theoretically, unless it was the right of a state to allow pollution or destruction of waters within that state. Because the Clean Water Act has always been a floor for states' rights. It expressly provides in the Act that the states can do more to protect their waters and that they can assert jurisdiction over more waters. As I said, Congress's powers are limited, but states' powers are not limited within their states. And the last one is that it was violating congressional intent. And I always found it very curious that people who weren't even alive in 1972 were arguing what they knew what congressional intent was when we were in fact relying on the limited congressional history that accompanied the act. In fact, some of the authors of the Clean Water Act from 72 were part of this whole debate. And that, in fact, congressional intent was being followed in that Congress intended to restore and maintain the nation's waters, not a very limited subset of those waters.
Terrific insight. Dave, from your time there and the Trump administration's actions on waters of the United States, how were they? What were the misconceptions? What were the distortions? What are your perceptions around all that?
I think I'm going to begin by why anybody would willingly take the AA of water job, knowing that you'd have to revisit and write Waters of the United States rule, is beyond me. So setting that aside, so perhaps suggesting I'm not a rational actor. But yeah, I guess there are a lot, like Ken mentioned, for the Obama team, there are a lot of misconceptions, and we had those as well. I guess I'll focus on two of many. I get the first is science. The talking point that we didn't rely on science or we ignored science. It just simply wasn't true. And one of my better decisions I made, and maybe the best decision I made at EPA, was to hire a PhD wetland stream ecologist to come in and help us craft a rule. And so I had a PhD in this area sitting next to me as we were crafting rules and crafting the language. But, and as an example, the issue of climate change, right? Last administration obviously took a lot of hits on that, but we use science to make the definitions we crafted adaptable over time. And so you take a look at flow regimes today, they're not the same flow regimes that they were 10, 15 years ago, and they're not going to be the same flow regimes 15, 20 years from now. And so how do you build a nationwide rule without having to revisit and make it adaptable over time? And we leaned into science for that. And so, what is a typical year? You look at hydrologic cycle and 30-year averages in an area in which you're doing the jurisdictional determination. So that's just sort of one example about how we thought about contemplated science. I think the other significant misconception is that our rule was based exclusively on Justice Scalia's test. The author of the conservative plurality opinion in Rapanos. Part of that was a messaging issue. The executive order the President Trump signed, instructed the agency to consider and be informed by the Scalia opinion. And so it establishes right out of the gate that it was going to be a Scalia rule. But as we looked at and crafted, I think as Ken mentioned, like the Obama administration did take a look at the multiple Supreme Court precedents out there and tried to balance Riverside Bayview, the Swank decision, and the opinions in Rapanos to come up with what we thought were the rules of the road, the guiding principles, and then tried to stay within those guiding principles. If Scalia was alive today, I think he'd take exception to some of the jurisdictional calls we made. And so I think I'd push back on this is just a Scalia only rule.
Gotcha. Well, you both have mentioned the idea that some people think you went too far. Some people didn't think you went far enough. These are the various stakeholders that are out there. And I'd love to kind of hear about your approaches to gathering input from the various stakeholder categories, to working with them, and how you tried to find success in those relationships. It's very, very challenging. You can't ever make everyone happy. That's not going to happen. So kind of a wide open question there on stakeholders and how that all goes and how you define success or feel like, okay, we landed in a good place when it comes to stakeholder opinion. Let's go with Dave first on this one.
Yeah, well, from a stakeholder engagement, Travis, I think this is where desire runs smack dab into reality. You go in and want to do listening sessions and you want to do all the stakeholder outreach and you want to get people in a room. And quite frankly, the EPA career team and core career team do a really great job in that regard and develop great plans for trying to gather the information, not just in the formal public comment period, but the stakeholder listening sessions. I really, wanted to do that. I'd worked in a couple of states and saw some opportunity for enhanced relationships between the states and the federal government. From a successful standpoint, there are a couple of days where we pulled in, 8 or 9 different states from different parts of the country with different political affiliations into a room, the map room, in the East Building at EPA, and for 2 days just talked about WOTUS and how to come up with common ground. And then in that same time period, we also pulled in the tribal interests and spent a couple of days in the map room doing the same thing. I think the what we got out of one, learned a lot, but in the state conversation, even in that where only 9 states are there and seeing wildly varying views of what should be regulated and not regulated was just a little snapshot as truly how hard this is. And so, I've said it multiple times, when I'm talking about this topic, we were aiming, that the environmental groups and the public property rights groups both really didn't like what we did. And you can't satisfy both in this context. And then in the middle, where the regulator entities, I think, where we were aiming effectively mild disappointment, but can you live with it? And so, as you're measuring success through mild disappointment, it's an odd place to be, but that's what we did. So
Yeah. Yeah.
it's tough. It's really tough in this context.
Sure, sure. Yeah, that's tough when your measure of success is everybody's somewhat disappointed because you didn't go too far one way or the other and you landed somewhere in the middle. But Ken, your thoughts on working with stakeholders, success on that front, and so forth.
Well, for us, we did everything that we thought we could possibly do to engage stakeholders in the process. We held over 400 meetings, briefings, many in person, many electronically. We held a number of those in DC at headquarters. We also tasked all 10 of the regions with doing outreach so people could participate who didn't care to travel to Washington or didn't have the ability or desire to do something remotely and electronically. We all know from having lived through COVID Zoom that doing everything electronically is not the best way to have a 100% fruitful conversation. I personally attended about 70 of those events to try to learn as much as I possibly could from everyone. And I think that the success that came out of that was that we were able to make choices with better information. And that really is the key to me. It's important to hear what people's thoughts and opinions are, but we also really wanted to hear data from them. We wanted to hear some real world thoughts on our proposed changes to the jurisdictional rule. I'll give you a couple of examples. I made several trips out into the agricultural community to get out of DC and talk to people. One in particular, I spent a day working with some representatives of the agricultural community, going out onto a variety of farms where people wanted to talk to me about looking at our proposed rule and talking about this is how they view it would work when it was applied in their daily lives. And as a result, I, in fact, came back and tasked the team with making changes from the proposal to the final rule. And so success to me was that kind of information that enabled us to come up with a better rule. Another example between proposal and final was how the final rule treated roadside ditches and ditches on farmland. And the intersection between what was necessary to provide sufficient drainage, flood control, and economic opportunity, and combine that with how to meld that with how do we protect water quality, knowing that that is the ultimate goal of the Clean Water Program. So those are just two examples. But as I say, those were changes that were made because of the success of the stakeholder engagement. Now, as Dave indicated, engaging with a stakeholder and listening to them doesn't necessarily mean that they're going to get what they ask for, but it can help make a much better decision on the part of the agency.
Sure. Every time something happens with waters in the United States or between the big actions, there's so much voicing of opinion by these different stakeholder groups, you know, on their social media accounts or in the press. This has been a very active issue for many entities out there, environmental groups and, like you said, home builders or whoever it might be. Why is the waters of the United States jurisdiction, why is this such a big deal, such a big issue, such a focal point for so many stakeholders out there? Ken, we'll throw this one to you first.
Okay. Well, I think in the most simple terms, it's people see regulation under the Federal Clean Water Act as a threat. And to their way of life, whether it's their economic way of life or their social way of life, or just how they see their role in the environment. And when I say a threat, it can be a threat in both directions. Overregulation can be viewed as a threat to economic interests. in particular, and underregulation can also be a threat to economic interests as well. And also to aesthetics, to people that are concerned about what kind of a place do we leave for our children and grandchildren, and those kinds of issues. And so when you have people that think of a regulatory program as a threat potentially from both directions, then it becomes a very serious issue for those interests. As we talked about earlier, people in the agricultural industry, the property development side, resource extraction, they see overregulation as a threat. People in the outdoor recreation economy see underregulation as a threat to their economic well-being. People in the conservation and environmental communities see that as a threat to their lifestyle and what they want to do. There are a lot of really conservative people who go trout fishing or go duck hunting. And so it doesn't always break down on ideological lines or on political lines, but in fact, there are so many there's so much diversity of interest in who has an interest in protecting water and who has an interest in being able to develop and maintain an economic use of water, that it creates a world where trying to get the two sides in the same room and come up with the same conclusion is just extremely difficult.
Yeah. Dave, your thoughts on why this WOTUS issue is just so central to so many of the stakeholders out there, and they've invested so much energy and time and resources in sharing their opinion and trying to mobilize and so forth.
Well, I think Ken did a really nice job laying out a lot of why this is such an important issue. And so I think I'll add and maybe summarize a bit. It's the uncertainty. Ken mentioned, I think it was a great example of the AIR program, right? You know what it applies to. And in the WOTUS context, there's this gray area. And so over time, that gray area, Travis, you mentioned energy and investment. Now it has sort of taken on this emotional, religious significance. And so it's building upon itself. But breaking it down to, I think, just a simple, single word, I'd say uncertainty. And it's, where you have uncertainty, how do you plan your affairs? And so if you're a regulated community, what you can do on the landscape, comes down to cost, money, certainty, and planning, how to get financing. And so if you have a parcel that you may or may not have irregulated water, how do you grapple with that? And that is a really, in an investment context or the regulated community context, that lack of certainty, I think, matters. So it's, I think I'll leave it at that. That's a long conversation, but I think the uncertainty really is a core issue on it.
Sure. How much of this back and forth, this tennis match, this ping pong match, is about policy choices and really the Clean Water Act jurisdiction, and how much is it about politics, really? You see a different administration, political party come in, boom, it goes the other way. And obviously we're in this kind of hyper political environment. Each administration is maybe expected by their supporters to do certain things. That's maybe a tough question, or maybe it's a really easy question. Dave, we'll go to you first on this one.
I think it's becoming much more about politics and perception and perspective. There are obviously important drivers, and Ken just laid out several for, all stakeholders have connections to the issue for legitimate reasons. But over time, I think it's really becoming about politics and perception. The war over WOTUS is becoming a war for the sake of a war, and then that's maybe a bit overstated, but I just think if you can drill down and actually take a look at the true dispute in WOTUS, you can really get down to a fairly narrow set of issues. But the talking points, I think, overcome or overwhelm those narrow sets of issues.
Yeah, Ken, your thoughts?
Well, I think that there is a heavy element of of politics involved in this. I do think that science has an important role to play. We always characterized the extensive work that ORD, our Office of Research and Development, and the Science Advisory Board, and what they did to help inform the decision was extremely valuable to the agency. But we always emphasized that science informed the decision; it did not make the decision, because we were tasked with interpreting a law that politicians had written in 1972 and handed to the agencies to implement. And as Dave mentioned earlier, Congress was not particularly helpful in terms of defining what the scope of the act was. Now, it's no secret that part of the reason that Congress wasn't all that helpful is because they couldn't answer the question themselves. I worked enough years on Capitol Hill, and I can't tell you that there were many times when we sat around a table and we couldn't agree on how to phrase or define something, and ultimately the decision was we'll leave it up to the agencies. And so we did. And so in 1972, the whole scope question was heavily debated in both chambers, and Congress ultimately, as you can see, sort of punted, and it was a pooch punt at best. And so it lives in a political world. There's no way to get around that. But science is really key. If you're going to take approach that we're going to try to maximize, maximize is probably the wrong word, because I don't want to indicate that we're going to stretch, that we should stretch everything to the nth degree. But if you're going to try to be as protective as you think Congress intended the agencies to be, then you need to rely on science to draw some of those lines, and how do upstream waters affect downstream waters. As I said earlier, many water bodies there's never a question of whether they're covered by the Clean Water Act, and discharges would require permits. It's smaller water bodies. David mentioned the distinction between intermittent and ephemeral streams. Well, that's a hard question to answer. But you have to take a look. What does the science tell you about the value of those streams in terms of protecting downstream waters? The same for water body, or for wetlands that are not directly adjacent to a navigable water. Then you have to look at the science and say, does the science indicate that there's enough of a reason to want to protect these waters? And then ultimately the agencies are going to say, well, the science says, yes, they're really important, but is it important to us politically? No, the waters aren't particularly important, but is it still important to do it to protect them politically, or is it important to us not to? And so those questions always have to be asked and answered when you get farther and farther from the waters that everybody would agree should be protected.
When we were kind of preparing for this podcast, you all raised a really fascinating point, maybe surprising point to a lot of people, but I thought incredibly insightful. And that's about really the overall importance of this waters of the United States definition, and particularly in comparison to other sections of the Clean Water Act, that maybe this has been magnified a bit more than it should be. This war over WOTUS, like I think you said pretty aptly, Dave. Ken, what are your thoughts on that?
Well, I think that the definition is critically important, because from the regulatory program, the whole act is triggered by whether or not a water is considered to be a water of the U.S. And if it is considered to be a water of the United States, then you need a permit, or you have to comply with other provisions of the act if you're going to discharge a pollutant into it. If it's not covered, then the regulatory program of the Clean Water Act simply doesn't apply. And so any prohibition on pollution or destruction is going to be something that the act doesn't protect it. It also means that a water feature would not be eligible for cleanup or of hazardous substance or oil pollution spills, because that provision of the act is also written in terms of navigable waters. But and I'll let Dave expound in a little bit more, because I know this is an issue that he's been very articulate on, and that is, but the Clean Water Act also has a lot of provisions that are non-regulatory. And so the question then becomes, are they sufficient to provide the restoration and maintenance of the nation's waters that Congress outlined as the objective? And so I think I'll let Dave take it on to the next step.
Yeah, Dave, what are your thoughts on this angle here?
Yeah, well, I guess the perspective I bring is, as a former, I grew up in D.C. as professionally, as a policy wonk, and there was this focus on WOTUS and the jurisdictional issues. And I think the thing that people forget is that it actually is a very large statute. It's a very complicated statute, and I spent as much or more time running EPA Office of Water as a bank. I mean, and so the most important programs, both on the Clean Water Act and the Safe Drinking Water Act side, are really the money, the grant programs, the loan programs that Congress takes taxpayer resources and it funnels it through the agency to then wheel it back out to build infrastructure, to develop protective standards. And so, in the grand scheme of things, I think Ken is right. WOTUS is critically important because it tells you where the jurisdiction of the federal government begins and ends. I think what's lost in the conversation, quite frankly, is, there are 50 states out there that have very, very capable programs. I work for 2. And so the conversation is not just, under the Clean Water Act, if the federal government doesn't regulate, it's not regulated. There are states there that have amazing programs, but it is important. Where you establish the standards, what funding the states may get, how do you prioritize certain water bodies in recovery? Obviously, WOTUS is integrated into that entire suite of regulatory solutions under the Clean Water Act. But as I spend time, with Andrew Sawyer's team and the NPDES permitting program, and in their state revolving fund program and the funding, there's so much that the Office of Water does that the word WOTUS never really crosses their lips. And so I think in that respect, WOTUS probably has an inflated sense of itself in the policy debates within DC.
Mm. Last question, maybe the toughest. Is there a sweet spot? Is there a way to reach a compromise? Like, if you were to take the politics out of it somehow, which is a great challenge, if you two as individuals that led the Office of Water under different administrations, different political parties, were tasked with going into a room and forging a compromise, what might that look like? Is it possible to reach one? Who wants to take a swing at that?
Oof. Well, I'll start. It is it's the Moneyball question, right? Obviously I'm biased. I thought we tried to aim for compromise. Obviously there are folks who wildly disagree with that on both sides. But I would like to believe that compromise is possible. But whether or not, because of the spiritual significance and the emotional connection to the issue, it's feasible is an open question. I talked not too long ago to a Western States water group, diverse membership of the states. I love them, great group of people. And they asked this question, and I sort of turned it back around on them and said, look, if this group can get together and come up with a compromise, and just focus on the disputed issues, right? Intermittent ephemerals, the isolated, ponds, wetlands, as you get a little bit further away from the main stem. If you guys can come up with a solution as the diverse group of states and make a recommendation to the EPA administrator, I think that would carry a significant amount of weight. And of course, the reaction in the room was, yeah, how do you get Wyoming and California on the same page, right? Mm. But I would, if I would try, I would really try to get states to come up with a compromise solution and make a recommendation to EPA that if the states can live with it, That is a huge, because the states are sort of the litigation drivers in today's world. It wasn't the case 10, 15 years ago. It was industry or ENGOs, and now you have blue and red state AGs who are really driving national policy litigation. If you can get the states to compromise, I think you've got a chance. I'm confident Ken and I could get in a room and probably map something out if we didn't have to worry about any other constituencies. But it's I don't know. I don't have a lot of hope, and so each administration that comes in is just going to have to find its way, and ultimately, I think either Congress or the Supreme Court is going to have to answer some questions for us.
Interesting. Ken, your thoughts on the possibility or the path to a compromise?
Well, obviously, if there was a readily available compromise, it would have been found a long time ago. Because it hasn't been for lack of searching. I think a compromise is an extremely difficult concept in today's world. The idea of compromise seems to somehow be a litmus test for politicians that are seeking office. And, people are afraid of having primaries run against them because they were viewed as being too willing to compromise with members of the other party. To me, that's just, thank you very much. That's a recipe for stalemate, inaction, and ineffective government. I mentioned, Travis, when we talked before this, that, when I came to the Capitol Hill in the 1980s, we did an awful lot because people compromised. I never lose sight of the fact and remind people that, both the 1972 Clean Water Act was enacted over a veto with large bipartisan majorities, and the 1987 amendments to the Clean Water Act was enacted. They were enacted over a veto with very large bipartisan majorities. I don't believe that today, if you put the current Clean Water Act text before Congress, that you could pass it. And so that's the kind of climate that we currently live in. And, there's a lot of ways people look at compromise. People talk about, well, if the people on the left don't like it and the people on the right don't like it, I must have found a happy middle spot. But my experience was that the way you found compromise was that people came into a room with the intent of coming out of that room with an agreement. And if the parties go in wanting to come out with an agreement, then both sides should walk out saying, I got enough of what was of importance to me to say that I'm willing to support this package. And today's climate just isn't really very conducive to that. I think another problem I wanted to focus on in terms of compromise, Dave and I probably, if just the two of us were left, I'm guessing that we might very well come out of a room with a compromise. But we're not starting with a blank sheet of paper. And that's the problem that we have right now. We have a statute that's been in place for 50 years. We have 50 years of experience at the state and federal level in implementing that statute. The agencies have gone through 50 years of experience. The states have gone through 50 years of experience. We have 50 years of court cases from district courts all the way up through the Supreme Court that have to be reconciled with any action that the agencies might take. And so the blank sheet doesn't exist. I think that Dave's suggestion of trying to get a diverse group of states in particular to come up with a position would be extremely helpful to the agencies. But even then, the agencies would have to view it as informative to their decision, because the agencies are going to be the ones that have to reconcile anything that they do with what they believe the law allows them to do and requires them to do. And that's one of the great difficulties in trying to develop the idea of compromise. When I was at the agency, we would have welcomed the states groups coming in and speaking with one voice and saying, we think this is the best way to address the issue, because ultimately they are all representing the people closer to the governing entity than the federal government does. And that would have been extremely helpful, but the states weren't capable of doing that. As Dave mentioned, states are parties to the litigation. You've got a number of states who are litigants on both sides of the 2015 rule. And so you end up in this dilemma where compromise may be out there, But the political climate right now is extremely unfriendly to the type of compromise that would be necessary, because ultimately a true compromise would require Congress to act, and Congress is, I think, incapable of acting on any of the significant environmental statutes, Clean Water Act among them.
Well, maybe the follow-up to this is going to be a live stream of a conference room, and put the two of you in there, maybe someone from California, someone from Wyoming, and locked doors, drop pizzas and in through the ceiling, and just stay in there until this thing gets done, and people can watch that happen.
Well, that would only be acceptable if you allow both Dave and I to edit whatever we want out of your recording.
Exactly.
Fair enough.
I think all great compromise does begin with pizza, though. So that's the first good step.
You see, there we go. That's, if anything, there's any takeaway from this conversation today, it's get a pizza involved and see if that can help things.
Yeah, they begin with pizza and they end with beer.
There you go.
Yeah,
there you go.
exactly.
Yeah, sure. Well, Ken and Dave, I really appreciate having both of your thoughts for this. I feel very fortunate to have you both come together for this conversation. I appreciate your willingness to do it. Thank you both very much.
Yeah,
Well,
thanks,
thank you, Travis.
I'm sorry, Ken. I cut you off.
I was just going to say thank you, Travis, for the invitation. I enjoyed our ability to share our thoughts on this critical issue that it really does need to. It needs to be. It needs to be made more stable for everybody involved, whether you're a regulator or the regulated community or the beneficiaries of that regulation. Stability is going to be key, because the next administration can't simply come in and say, we're going to rewrite it again, and then the following administration and the following administration. It just will not work.
Mm-hmm.
To that, we have complete agreement, Ken. So thanks. I likewise, Travis. Thanks for the invitation. It's been a great conversation, and keep up the great work. And keep up your podcast. You reach a lot of listeners and a lot of important topics.
Thank you very much.
Waterloop.
Thanks, everyone, for listening to today's episode. A special thanks to Waterloop supporters, Spring Point Partners, and the Walton Family Foundation. The Waterloop podcast is sponsored by High Sierra Showerheads, the smart, stylish way to save energy, water, and money while enjoying a powerful shower. Use promo code LOOP20 for 20% off at highsierrashowerheads.com. If you like Waterloop, please subscribe to the YouTube channel or your favorite podcast platform. Follow us on social media and visit waterloop.org to sign up for updates.
Waterloop, Waterloop, Waterloop.